In this short video, let's look at the process that we follow for a patent application. We always start with a non-disclosure agreement because it is for your safety and your confidentiality. This agreement doesn't cost you anything, but it is a very strong document which says that we as a attorney firm or IP firm or patent attorney agree to you that whatever information that you are telling to us, we will keep it confidential and will not publish or misuse anywhere. So by the time it comes into public domain automatically, that is when we file the patent application, and it will be published anyways. So by that time it is our job to keep it confidential. Once we sign the NDA, the main fear that you have is someone will take this and file it on their own name is gone, because we are bound by that agreement now. Moving ahead, we receive an invention disclosure from your end. Now, how that invention disclosure would be received, there are multiple ways to do it. There is another video which is part of our email, like what information you need to file patent application, that in detail goes for the ways and forms in which we receive the invention disclosure. But to refer to it in a short way in this video, we have something called invention disclosure form, or what we can say invention disclosure questionnaire, wherein we have 10 to 15 questions about your invention, like what your invention is doing, what problem it is solving, how we are different than other competitors, what you think as innovative feature of your invention or inventive step of the invention, and any competitors that you see which are very close to our invention. And your answers to questions like these will help us understand the invention in a proper way. Like they say, we should be in a position to stand in your shoes and understand the invention and understand what needs to be protected in a proper way, so that we can draft a good patent application. Now, assuming that you have submitted sufficient information, you might not be knowing answers to all the questions, but let's say you said answers to 8 questions and you submitted the document. It can always be to and fro. In case we feel like the technical feature is missing or we need further information from your end, we can always call you back and get the required information. And in fact, we actually set up a call with you, generally the video call, wherein we discuss the understanding of invention from our end along with you. So any which ways it would be to and fro communication. So you need not be perfect here, but try to submit as much details as possible so that we would understand what exactly we want to patent. So let's jump to the email, and if you could see, there are about 9 to 10 steps in getting patent granted. So we'll look at it one by one. We signed the NDA, we discuss about invention disclosure, we schedule a call to discuss our understanding, and we get all the technicalities of the invention. Now the next step is novelty search. If you can refer to the end part of the email wherein the tabular format is there, the novelty search is a step wherein we want to check if our invention is novel at all. Now this is an optional step. Sometimes you need it, sometimes you don't even need it. It's totally your call, because someone who is really skeptical or someone who really want to ensure that before going into the investment for complete patent application, I really want to be sure whether I have the novelty or newness or not. So as per patent law, at least some aspect of the invention should be new. At least some aspect should be new. So if not 100%, but at least 2-3% or some arrangement, some component or something should be new, wherein it can proceed for the patent application. So it's your call. You can actually skip the novelty search, or you can take it if you really want to be sure about going ahead for patent application. The next stage is the most important stage, that is drafting patent application. Now there are multiple videos along with this email as well, which states the importance of having a patent attorney or patent agent working on your patent application. And that is for obvious reasons. Like drafting a patent application is most complex job. I mean, you would be getting patent for the patent application, how well you draft the application. It is about the explanation of the invention, how well you do it. It's a techno-legal document, obviously. So whatever is there in your brain or whatever the research that you have done, it has to be well represented in a document, that is patent application. And it's not at all similar like the normal thesis or project report or technical document that you see. If you really want to check, you can just go on Google and search for a few of the granted patents in your domain, and you would get an idea. Like writing a patent application is whole new level of skill. I mean, it definitely involves a lot of understanding of Patent Act, patent manual and patent rules, along with the ways you write the patent application and the procedural formalities, and a lot of things need to be taken care when you write a patent application. So it is always recommended you go with an experienced patent agent if at all you are serious about your invention. So moving ahead, when we draft patent application, it generally takes 15 to 20 days, or rather couple of working weeks, we can say, excluding the holidays. So when we are ready with the drafted patent application, we send it to you for your review and your comments on anything, whether you are satisfied with the scope that we are trying to cover with the invention, anything else that you would need to add or to discuss with it. And then upon your review, we file it in patent office. Now what you get is a patent application number when we file a patent office, and a receipt regarding the patent filed. So now you can write patent pending for your patent application. Now we already discussed what are the advantages of patent pending. You might refer that article, or you can listen to that video. That patent pending gives you a lot of benefits, and you can actually do 95-98% of the things that you wanted to do with your invention, like start selling your invention, start promoting it, do the advertisement, talk to your investors, talk to your channel partners, or whatever you wish to do with it, without the fear that someone will steal it and file it on their name. And patent pending gives indication or signal to the competitors, like the patent might be coming in future, so they are less likely to copy it and compete with you when they see the patent pending number. So there are lots of other advantages also. You can refer that article. Moving ahead, there would be early publication request. Generally it is done, the relevant fees and forms are mentioned there. The early publication request is done when we don't want to wait for 18 months for the publication of patent application. Generally it is published after 18 months when we do nothing about it. But if we file the early publication request, we can get it earlier, that is about in a month or so, we get the patent published. It's not grant, it's published. Now next is examination. If we go by normal route, the examination, the official fees for an individual is 4,000. But if we take the expedited route, in which you don't need to wait for 3 to 4 years, or rather more than 2 years to get the examination, it can happen within 6 months. And what that means ultimately is we can see the granted patents well within 1 year, or maybe 1.2 years. Now when the examination is done, generally we get some of the other objections, and which is called as a first examination report. So FER is first examination report, in which the examiner goes through your patent application and raises some of the objections. Now it could be formal objections, it could be technical objections, like we don't see any novelty there, or the abstract is not really communicating the technical nature of it, or the title is not 15 words. I mean, there could be different objections for different purposes, or unity of invention is not there. There are multiple inventions combined in one patent application. Now when we receive first examination report, we prepare a written response to it and try to overcome the objections, may it be formal objections or may it be technical objections, like novelty is not there or inventive step is missing. We write a written response and try to convince the controller that the patent is indeed eligible to be granted. And sometimes if a controller is of opinion that he wants to have a hearing with the inventor or with the patent agent, he would send such request, and a hearing can take place, wherein it would be mostly in the form of video conferencing, and after listening to our arguments, he might offer further changes, and when we comply to it, the patent would be granted. This completes the procedure for patent application to patent grant. However, if you still have few questions, we can always discuss on an audio call, a video meeting, or a visit in office. Thank you for your time. Take care.